All right, welcome everyone to this session of ours. My name is Lior Samfiru. I am the employment lawyer. Very easy to remember that. I'm the employment lawyer, and I'm here live to answer your questions, to help you with your workplace situations like I do every Wednesday at this time. I am live here for your benefit and for your interest if you have an interest in employment law. So I'm one of the co-founding partners of Samfiru Tumarkin LLP. We're the largest employee side law firm in this country. And by this country, I do mean Canada. Sometimes I get calls from the US. We're in Canada. So you're here now listening to me to learn about employment law and to hopefully have your questions answered. So I have plenty of stuff I can talk about, and I will, and examples to give and stories to tell. But this is much more interesting if you take the opportunity to ask me questions about whatever is bothering you, whatever your issue is or your problem is. Now is the time. You type in the question, you press enter. I see it, I read it, I answer it, and then you can have that information. So we're live right now for that purpose. Questions are already coming in. And by the way, don't actually wait till the last minute, to the end of this session. It never fails. Always right at the end. I get like 3 questions right at the end, and I never get to them because I have to be done here by a certain time. Ask now. You have plenty of time. Let me give you some other contact information beyond just what we're doing here live. If you want to connect with me and my team off social media, you don't like this whole social media thing, you want to have a private email exchange, or you want to have a private call, private consultation, easy to do. All you have to do is you go to employmentlawyer.ca. You see that address below me? employmentlawyer.ca. And when you go there, number one, you get all the contact information that you need, phone number, email addresses. If you want a form to fill, you have that as well. You can also there read a lot more about employment law rights, constructive dismissal, wrongful dismissal, severance, layoffs, harassment, human rights, you name it, you can learn that there. But that's for after. Right now, I am here to talk to you live. So let's start answering some of your questions. Don't be bashful. Maybe you lost your job. Maybe your boss told you, you know what, it's not going to work out. We have to let you go. Can they do that? If they do that, what does that mean? Do they have to pay you anything? How much do they have to pay you? Is it all legal? Ask the question. If you think your boss is not letting you go, but they're trying to convince you to leave, they're trying to push you out, they're kind of being sneaky about it. Can they do that? And what should you do about it? Well, it starts by asking the question. I think you get the idea. Whatever the issue, we have answers and the solutions. So again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. I'm going to start now doing what I've got here to do, which is to answer your question. So I'm going to start in the order. Christina has the first question from Facebook. She says, can your contract include terms to reduce your pay from a yearly salary to hourly? So yes, your employer in the employment agreement can stipulate pretty much anything. So your employment agreement can say, yeah, you're getting paid a salary of $50,000, but we have the discretion to change it to hourly, or we have the discretion to reduce your pay, or we have the discretion to reduce your hours. Now, these are things that your employer cannot do. Your employer can't just reduce your pay or change your hours unless you signed an employment agreement that specifically says you're going to allow them to do that. So your employer cannot change you from hourly to salary or salary to hourly unless you sign an employment agreement that says, yes, they can. So that employment agreement is such an important document. You can have so many terms there that are problematic, that could impact your rights, that could cost you money. So you have to pay a lot of attention. If you're accepting a new job, or if your employer just presents you with a new employment agreement to sign, don't just sign without understanding what it does and what it means. If you don't care about it now, you're going to pay for it later. So what do? Well, you read it carefully, but even better, you send it to me. Let me see that agreement. Let me tell you what it says, what it does, whether you should sign or not. Okay? Very, very important. Too many times people sign that agreement and don't realize what they've actually given up, what they've actually done by signing that. It's a great question there from Christina. Be smart. Contact me if you want some help with that. Again, employmentlawyer.ca. All right. Next question on YouTube comes from, I don't know how to pronounce it, Soup Telf. Best I could do. So Soup Telf asks, can HR tell me I will be triggered coming back into the workplace after being sober 2 years from alcohol? I'm not sure exactly what you mean by triggered. So you'd have to elaborate. I don't know what you mean by you will be triggered coming back into the workplace. If you're coming back to the workplace after being off, they have to allow you to come back to that job if it's available. If you need accommodation, they have to accommodate you. So I'm not sure exactly what you mean there by triggered in this context. Next question comes from Makeba Nicole. Can an employer force you to take on a job that is not originally part of your original contract? Well, it depends how different that job is from your original contract. So I'm going to give you an extreme example, okay? So if you are hired to be a secretary, and then they say, now we need you to be a janitor, clearly that can't be, right? That's too big a difference, right? But if, for example, if you were hired to be a secretary for person A, and they say now you have to be a secretary for person B instead, then that's okay because it's not that big a change. So it really does depend how big a change. If it is a significant change, very different job, completely different, or even a demotion, that could be considered a constructive dismissal. That means you may be able to treat that change as a termination of your employment and make your employer pay you your full severance. So again, anytime we look at a change to the terms of employment, change to hours, to pay, to job responsibilities, the question is it a significant change? If it's a tiny little thing, yeah, usually your employer can do it. If it's a significant, if it's a big deal, then no, they can't. So happy to give you more info, Makeba Nicole, if you tell me more about your situation. All right, let's see. Continuing. Danielle on Facebook has a question. Okay. Can they change? I'm assuming you mean change your job description and add 2 more jobs to you without changing your pay. Well, again, if it's exactly what I was saying before, Danielle. If it's a big change, so if it's okay, you used to do 5 things, we're going to add these other 2 things, but they're minor. They're going to take you 20 minutes a day to do. Yeah, they can do that. But if it's a big deal, now they're giving you a much different job. It's going to take much more time to do it. It's going to be a lot harder. No, that they can't do that. That again also would be considered a constructive dismissal. So we can't say yes they can or no they can't unless we know exactly what is that change and how that change affects you. Hopefully that makes sense. If you have any follow-up there, Danielle, just ask. Okay. Makeba Nicole, you say that it's in the IT field and you're an administrator, but you're not telling me what it's changed from and to. N. Stinson has a question on YouTube. Written letter from employer says I'm fully remote. Does a verbal comment from a manager, that may change at some point, trump my legal right to work from home, federally regulated? Well, if your employer made it clear to you that you're going to be working from home indefinitely, then no, they can't change that, okay? If they were saying you're working from home now and that's all we know, then that may be different. So it's a question of how do we establish that the agreement was that you'll work from home remotely? If you have something in writing from them saying that, you're golden, okay? If you have an email to that effect, if there's an employment agreement that says that, if there's anything in writing that confirms that you're a remote employee and that's it, not temporarily, that's it, indefinitely, they can't change that. If they try, easily, that would be a constructive dismissal. Okay, so hopefully that makes sense. Again, keep in mind the overall theme of what we've been talking about so far is your employer cannot make significant changes to the terms of employment. Now, going from working remotely to working in an office, you better believe that's significant, right? So if they're changing it like that, no, that's a constructive dismissal. So always ask yourself, is it a significant change? I'm going to continue answering questions, but for those that have joined us in the meantime, my name is Lior Samfiru. I am the employment lawyer. I'm one of the founding partners of Samfiru, Tumarkin, LLP. And as you've been seeing, I'm here live answering your questions. So don't just watch, ask the question. Make sure that you feel better about your workplace situation because as you've been seeing, there are answers, there's solutions, there's things that you can do. So by all means, ask and I'll answer. All right, let's see. Next question is from Giovanni. I was let go. I used to work at IKEA restaurant. I've been waiting 2 to 3 weeks for my severance, but my employer refuses to pay severance. I've got papers to prove that I'm owed severance. Well, your papers don't prove that you have severance. The law decides if you're owed severance. There's no piece of paper that says you're owed. It's a question of, are you legally owed? So if you used to have a job and you lost your job, then of course you're owed severance. And unless you did something terrible, like you stole, you committed fraud, you hit someone, unless you did something terrible like that, your employer has to pay severance, and it's not up to your employer. But here's what you do. It's not complicated. You call me. You call my team. Our team, 90% of what we do is we help people get their severance, okay? It's not hard. A letter from us, it's all that it's going to take. So Giovanni, contact me off air, and here's how you do that. employmentlawyer.ca. You see employmentlawyer.ca. Right there, you'll see the phone numbers, the email addresses. Everything is there to contact me. You don't need to wait. Those papers don't help you. We simply need to get involved. We'll get you that severance and you move on. Now, for Giovanni and for everyone else, if you want to find out how much severance you're owed, so yeah, I know I'm owed severance, but how much? Is it a week? Is it 24 months? Is it somewhere in between? Here's what you do. You see that address below me, pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca. When you go there, you'll see our severance calculator, okay? Our severance calculator, as the name says, allows you to find out and to calculate how much severance you're owed. Whether you've worked for a company for a month or for 65 years, you can find out how much severance you're owed. And I bet you anything, it's a lot more than what you think it is. It's a lot more than what you believe, all right? Because that's how the law operates. So even if you work for a company for a few months, you could be owed a few months of severance. So that's why it's so important that you go to pocketemploymentlawyer.ca, use that calculator. In fact, it should be the very first place you go to. If you lost your job, if you're worried about losing your job, if you're curious to know how much severance you're owed, and by the way, it's free, it's anonymous, you don't put in any names, phone numbers, you don't put in there, you don't put in a credit card, nothing. It's just there for your benefit. Again, pocketemploymentlawyer.ca. Okay, Danielle, who was asking about a change to her job, has a follow-up. Started as prep. They were doing that onto of line cooking. Okay, so I guess you were being made, instead of a prep cook, to be a dishwasher. Well, no, that is a significant change. So that may be a constructive dismissal. So the question you have to ask yourself, Danielle, is what's better for you? Is it better for you to continue working with the dishwashing job, or are you better off to leave with severance? You can't physically stop. You can't physically restrain your employer from doing what they're doing. You can't call the police and then the police says, you have to stop. It doesn't work that way. It's either you accept it or you can treat that potentially as a termination and get severance. And if that's what you want to do, you'll need our help. Okay, you cannot do that on your own. So to do that, connect with me. Again, employmentlawyer.ca. Again, employmentlawyer.ca. And by the way, for you, Danielle, for anyone else, if you want to find out how much severance you'd be owed if it's a constructive dismissal, very easy. Just go to our severance calculator. I mentioned it already, pocketemploymentlawyer.ca. All right, continuing with questions, guys. You see how easy it is, right? You type it in, you press enter, and then you sit back and wait for me to answer. Easy to do. Next question is from Walter on YouTube. Started working for a new company and completed paid training. I haven't signed anything so far and wondering if they do ask me to sign one, will it be enforceable at this point in the relationship? So if you've already started working for the company, then even if they ask you to sign it, it's probably not enforceable. But still, you would be very irresponsible to sign something on the basis, well, I know it's not enforceable, so I'm just going to sign it anyway. Okay? If you're going to sign something, you have to assume that it's going to be enforceable. We never sign something thinking, well, it's not enforceable anyway, so I'm just going to sign. Who cares? No, that's a bad idea, because it could potentially, depending on the circumstances, ultimately be enforceable. It's likely not, but I wouldn't take that risk. So if they present you with something, okay, let's talk about it. Let's see if it's a problem. If it's not, don't just sign something. Very important advice here. Don't ever sign something just because you believe it's unenforceable. Very bad idea. That's an invitation for legal action down the road. Okay, great questions today, guys. Absolutely amazing questions. Next question comes to us from Dominique. She says, I started working in a kitchen a few weeks ago. I was told it was a training period. I would not be paid full pay yet. Is this legal? So you have to get paid for your time worked. So if you have an employment agreement that says you're going to get paid $30 an hour for whatever, for example, then they have to pay you that. If not, they have to pay you at least minimum wage. So Dominique, if you have an agreement with them saying that they're going to pay you for all your time at a certain rate, they have to pay you that rate. If not, they have to pay you at least minimum wage for that training. They can't say, well, it's training, so we're going to pay you less than minimum wage. It's illegal. You can't ever get paid less than minimum wage, even for training. And by the way, there's no such thing as unpaid training. Okay, if your employer tells you you have to do something, that's considered work. That means you have to get paid. Okay, even if they're saying, no, it's for your benefit, it doesn't matter. If there's no option, they have to pay you. All right, so hopefully that makes sense, Dominique. Walter, am I considered to be hired even though I was being trained? Yes, absolutely. Again, unless you sign an agreement that says we'll assess whether we want to continue with you after this paid training. So if you, but you said you never signed anything, which means, yeah, you're hired already. All right, Helen 2006 on YouTube. How much can you get for wrongful dismissal and bad faith? Could you please provide a range? So, okay, first of all, the question is, what is wrongful dismissal? Wrongful dismissal is a situation where you don't get the severance that you're owed, okay? Whether because the company didn't pay enough or because they said you shouldn't get any severance, okay? And for that depends on whether you work for 6 months or 50 years. It could be anywhere from 2 months to 24 months. And to find out, Helen, how much severance you would be owed, it's pocketemploymentlawyer.ca. Again, we have our severance calculator at pocketemploymentlawyer.ca. So a wrongful dismissal has nothing to do with whether or not they had a good reason to let you go, whether they lied about a reason. And it's because an employer generally can let you go pretty much for any reason as long as they pay you severance. Now, bad faith comes into play if they're doing something to hurt you. They're bad-mouthing you. They're making it more difficult for you to find another job. They're hurting you somehow. Then there could be additional damages. Okay, but generally, in 95% of the cases, wrongful dismissal is nothing to do with why you were let go, how you were let go, the reasons. It's all about the severance. Okay, and if you work for 2 months, you may be owed 2 months severance. If you work for 40 years, it could be owed 24 months severance. So the main factors that go into assessing how much you're owed is your age, your position, and the length of your employment. The longer you work, the older you are, and the more senior a position, the more severance is owed to you. Okay? So Helen, happy to have had your question. If you have a follow-up, let me know. If you have been let go, I don't care if you were let go for good reasons, bad reasons, no reason, if you work for a short time or a long time. If you have been let go, you call or you email me. No exceptions. Because here's what's going to happen. You're going to accept an offer that's not good enough, and then it's too late. No matter what, whatever the situation, you call or you email. And again, easy to do. Just go to employmentlawyer.ca, employmentlawyer.ca. All the contact information is there. All right, Moataz, sorry if I'm pronouncing incorrectly, on YouTube. Can I still get my company's reference if I'm suing them, and how to prevent them from retaliation in the future? So there's no legal obligation on a company to provide you with a reference, regardless of whether you're suing them or not. Even if you've done nothing wrong, there's still no legal obligation. So it's always up to the company to decide if they're going to provide you reference. But here's the thing. When we settle a case against a company, we negotiate reference. We negotiate, number one, a reference letter, okay? And in addition to a reference letter, we negotiate something that says that they'll provide a verbal reference. So if you have competent counsel, that's going to be part of the negotiation. If you don't have competent counsel, you have to call us immediately, okay? And how to prevent retaliation? Well, it's illegal to hurt you in the future. So if you find out that they've done something to hurt your job prospects, that's illegal. There's legal action that you can take. But will they give you a reference in the meantime? I don't know. But here's why they might. Because your former employer wants you to find a job as soon as possible. Because if you find a job quickly, it could reduce the amount of money that they have to pay you. So they don't want to pay you as much. So they want you to find another job. So if they can help you find another job, right, by giving you a reference, they're going to do that. So hopefully that makes sense. Again, Motaz, if it doesn't make sense, ask a follow-up. I'd be happy to answer. I think I'm caught up here on questions. So waiting for more questions from you guys. As I said, I'm live here. You still have 10 minutes or so to get that question in, to get me to read it and answer it. And just as I said that, another question came in, but take your opportunity now and ask that question. I'm Lior Samfiru, the employment lawyer, here live for you at your service. So let's see. Trevon has the next question. I've worked in a small family-owned business for 5 years, and it was close to home. It's now being sold to a big corporation and moving an hour away. Do I have to move or do I have any options? So if now your commute changes by more than an hour, that could absolutely be a constructive dismissal. So when the company does this, when they say, okay, we're moving tomorrow or whenever that is, you have two options. You can make the move, or you can choose to treat that as a termination, constructive dismissal. We've talked about that before, and get severance. So you can't physically stop them from moving, right? You can't go in there and say, I've decided you're not moving. They're going to move if they want to, but you may have the right to look at that and treat that as a constructive dismissal. Generally speaking, kind of a rule of thumb that I use in terms of a move is if it impacts you by more than an hour, 1 hour's time, usually we're talking constructive dismissal. If it's less than an hour, probably not constructive dismissal. So it's not really about the distance that the company moves. It doesn't matter if it's 5 kilometers or 500 kilometers. What matters is how it impacts you. Okay, if it impacts you by more than an hour, probably constructive dismissal territory. Okay, hopefully that makes sense. Right now, I'm still here live. And one of the things I want to clarify as I'm waiting for your next question is this. That generally speaking, the reason why you hear me say the word severance so often, it's not because I have this crazy fascination with severance. It's because from a legal standpoint, that is what the law can do. The law can help you get severance if your employer does something that they're not supposed to. The law can't really stop your employer from doing anything. Okay, it's not like in a criminal case where the law can stop someone from committing a crime. When it comes to employment law, a court, a judge, the law, the government can't stop your employer from doing something to you that they're not supposed to. What the law can do is deal with what the employer did. If the employer did something to you that they weren't supposed to, is to compensate you for what your employer did. So if your employer lets you go and doesn't pay you proper severance, they're ordered to pay you proper severance. If they change your job when they're not supposed to, well, that's a constructive dismissal. If they lay you off when they're not supposed to, a temporary layoff, by the way, is illegal in most cases, then they have to pay you. So oftentimes when people call me, they're upset about what their employer is doing and they want to stop that from happening. In most cases, you can't really stop it. You can get compensation. And usually that compensation is by way of severance. That's why you hear me talk about severance so often, because from a legal standpoint, usually it comes down to severance in terms of what the law can do for you. But the good news is that you're probably owed a lot more severance than you realize. Too many times, so many people tell me, oh yeah, I'm owed 1 week's severance for every year of service. Nonsense, not even close to that, okay? Go to pocketemploymentlawyer.ca, use our severance calculator, find out how much you're really owed, okay? None of that nonsense of a week's pay per year of service. You see that address below me, pocketemploymentlawyer.ca. All right, more questions that have just come in. Ask yours. Got a 5 minutes or so. You can squeeze one in there under the wire. So let's see. Samuel, is your boss obligated to pay while you are on sick leave? No, that's a great question. So an employer generally does not have to pay you while you're not working. So the deal with your employer is this: you come into work, you do the job, and we pay you, right? So if you're not working, your employer doesn't have to pay you. Now, some employers have sick pay policies, sick day policies, where they say we'll pay you for 2 days, 3 days, 10 days. So they have to pay you for those days. But the law doesn't impose an obligation. What the law imposes on them is the obligation not to fire you if you're sick, to bring you back, not to change your job, not to punish you, right? But they don't have to pay you. Now, you may have an insurance company through your job, short-term disability insurance or long-term disability insurance, that may pay you while you're off There's also government benefits through EI that could be available while you're sick. But generally, an employer does not have to pay you if you're not working, even if you're sick. All right, so that question is from Samuel. Next question on YouTube comes from JR. What is your best advice for contract to hire positions? Any pitfalls to avoid? I'm not sure what you mean by advice for contract to hire positions. I don't know exactly what you mean by that, JR, so maybe you want to clarify. Peter has the next question. Are clawback clauses always included in a severance package regardless of age? No, not at all. In fact, I'm going to say that maybe half included and half not. And a clawback clause is something that says that we'll pay you this amount of severance, but if you find another job while we're still paying you, we'll only pay you half of what's outstanding. So usually half the time it's included, half it's not. But here's the good thing. When we negotiate severance packages, we almost always end up getting rid of it. We negotiate a lump sum payment, no strings attached. That's reason 2,454 as to why you need to call us if you lose your job. So it's not just about how much severance you're getting. It's about, is it guaranteed or is it not guaranteed? Is what's included in it? What about your bonus, your benefits, your car allowance, your pension? So all those have to be properly included. So I bet you anything your employer didn't include them properly. So if you're trying to figure out, is this legal or not, or trying to do this on your own, you're wasting your time and you're going to get into trouble. Yeah, talk to us. Just like if you're sick, you're not going to say, well, I'm just going to figure out if I'm sick on my own. I'm going to figure out if my medical condition is serious and I'll deal with it. No, you wouldn't do that. You would see a doctor, right? So if you're going to see a doctor if you have a medical condition, you have to see us if you have a legal issue, certainly when it comes to employment law. Again, to connect with us, very easy. You see that address, employmentlawyer.ca. All right, next question from Helen. Apparently, a manager wrote an unjustified performance improvement plan to terminate me due to retaliation after complaining of bullying and harassment. How much more roughly can I be compensated through a lawsuit? Well, if your employer just wrote a performance improvement plan, you probably are not going to get compensated. If you were fired because you were complaining about harassment, that's a different issue. If you were actually fired. So if your employer just put you on a performance improvement plan, you're still working there, it's going to be tough, and any compensation is going to be minimal. But if you were fired because you complained about harassment, we call that a reprisal. Okay, it's illegal, and compensation for that can be anywhere from $5,000 to $50,000, depending on the circumstances. But again, I think you're putting the cart before the horse. So you're trying to figure out some things here in terms of why would I be owed. You need to have a proper consultation. All right, we need to properly assess your matter and tell you exactly in your situation, here's how much you're owed, and here's what we can do about it and how to get that for you. All right, so Helen, you reach out to us, okay? Employmentlawyer.ca, the way to do that, to connect with us. And you say you were fired. If you were fired because of that, again, I told you what that is, but you shouldn't, frankly, you shouldn't be now talking to us on YouTube. You should be talking to us in a proper consultation, all right? If you're fired because of bullying and harassment, because you complain, illegal. One of the most basic things, an employer cannot do that. So you need to get us to roll up our sleeves and get to work to make sure you get everything the law says you should have. All right. To connect with us, Helen, I wouldn't wait. I wouldn't wait till tomorrow. Do that now. Employmentlawyer.ca. All the contact information is there. We'll help you out to make sure that this wrong gets rectified. Guys, that's the time that I have for today. Always great questions with you guys. You guys ask the best questions. I'm glad I had the opportunity to be here. I'll be back next week. But as I've said to already a few of you, don't wait until then. Bad idea to wait until then. Let's talk today, tomorrow, as soon as you can. Go to employmentlawyer.ca. Connect with me and my team. That's all we do. Okay, if you have a real estate issue, don't contact us. We don't know anything about it. We can't help you. If you have an employment law issue, if you have a disability issue, you contact us. We've got your back. That's all we do. All right. So thank you very much. Always a pleasure to be here with you. I'm the employment lawyer, Lior Samfiru. We'll talk to you again very soon. All the best. Thanks.